This is embarrassing. I don't have anything turned on. Oh my God. What am I supposed to do? Oh, I know. Just play the show.
You don't need to tell your mother what I said. Get back on this screen. Turn your camera on now! Send them out of the room! Send those two girls out of that room! Now! Don't say a word, just send them out of the room. Oh, and go ahead and put yourself on mute now.
It went to her voicemail, so we'll just record it, and then I guess if they call, they can jump on.
Sounds good, Judge.
All right, sorry about that, folks. Okay, Bostic, we'll start with, so we don't have anybody in the Cobb booth yet, ACDC. So it's Angelo Houston, Mr. Dobbs. Number 5, Bostic, 23, CP 224424, 90 days without indictment. There's a $10,000 good bond as of December the 26th on theft by shoplifting felony. Pre-trial.
31 cycles, open case for theft by shoplifting, 23 SC 191671. There's a 2019 conviction for a forgery and a first. There's 6 conviction for misdemeanor theft by shoplifting, 2 FTAs, nothing further.
All right, go ahead, Mr. Dobbs.
Thank you, Judge. Mr. Houston is a native of Atlanta, born and raised here, never lived anywhere else. If released, he would reside at his mother's address, which is on Verbene Street, which is within the city limits of Atlanta. He is not on probation or parole. I understand that pretrial mentioned a open case. I know that he's working with my colleague, attorney Anir Rashid, on resolving that case and looking for some sort of behavioral program for him. So that is currently what's going on with that. He has 3 children spanning the age ranges of 2 to almost 10 years old. At the time of his arrest, he was employed at a Coca-Cola factory. But he has also had a injury with his ankle and is currently applying for SSDI. Judge, we have a fixed address for him. He is a native of the Atlanta area, very strong ties. I understand he has an open case, but we are working on getting that resolved. For all those reasons, I'm going to ask for a total bond for Mr. Houston, not to exceed $2,000. Thank you.
All right. Go ahead, Mr. White.
Judge, perhaps I am uniquely qualified to talk about his open case, since I am handling that open case in Judge Mao's courtroom. And based upon this defendant's criminal history, we're trying to verify, but it looks like that case will be transferred to the complex division based upon the fact that he has more than 5 felony convictions in his lifetime. If it is not, currently the state's offer in that case is 10 years to be served in confinement, which I know Miss Rashid now Rios is not real happy about. That just brings to bear this, Judge. He is a danger to basically every retailer in the metro area. Also, he has a charitable, I think is the word I'm going to choose, bond at this point. The state would be opposed to any reduction. And in fact, given that this is a reconsideration hearing, the state would request that, given the fact that he committed this offense while on bond for another theft by shoplifting, after having picked up no less than 6 prior theft by shopliftings, as well as additional felonies, not theft by shoplifting, the state would request a bond of not less than $100,000. That's really the only way we're going to be able to keep track of this individual. The only way we're going to be able to keep him from preying upon retailers and others in the metropolitan area. Nothing further.
Anything else, Mr. Dobbs?
If he can't make the bond that he currently has set, which he cannot, I don't see the purpose of a bond increase. The state already has him in custody. I'm asking for $2,000. Any reduction that the court would give would be greatly appreciated. Thank you.
All right, no drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Stay away from Phipps Plaza at 3440 Peachtree Street in Atlanta, Georgia. Stay away from all malls in Fulton County. You're going to have an ankle monitor if available, paid for by the county with a 24-hour curfew. Court, lawyer, and medical. Court, lawyer, and medical. $9,500 good bond. Best of luck to you, sir. All right, Pierre Wilson. Wave your hand if you're Pierre Wilson. There you go. All right. Number 4, Bostic 23 CP 217662, 344 days without indictment. We got a $3,500 good bond, split bond as of December the 6th on willful obstruction, felony, and criminal trespass. Rah.
Would you, Pierre Wilson?
Yes, ma'am.
56 cycles of prior robbery, couple of battery, family violence, 1 FTA, couple of FTAs, couple of arrests for probation violation, nothing further.
Go ahead, Ms. Beck.
Thank you, Your Honor. Mr. Wilson is 24 days shy of being incarcerated for a year. He's been there the entire time at Rice Street. We had his preliminary hearing back in August, and nothing has happened since then either. So we will be asking for a UJR, but I'll go through the factors as well. Mr. Wilson is 38 years old. He has a lot of family that lives here in the state, including but not limited to his mom and his cousins. He went through the 10th grade at Washington High School. He currently receives disability. However, that is put on pause while he is in jail. So he is actually not receiving any money right now, which is why he's unable to bond himself out. He has lived in Georgia for 30 years. We do have a good address for him. It is in Decatur. He would be living there with his mom. We will be asking for a UJR or a bond not to exceed $500, Your Honor. I have spoken with his mom. His mom cannot afford anything over $50. So we will be asking for a UJR. It's been almost a year. If the state was so inclined about this case, they could have indicted, well, almost 365 times. So with that, Your Honor, I am asking for a UJR for Mr. Wilson.
Is there MH, Ms. Beck?
Yes, Your Honor, and he does have a program set up at the Clayton Center.
Okay. All right, go ahead, Mr. White.
Yes, this is a felony obstruction of law enforcement officer. This individual has 56 cycles in less than 20 years. And in one of those 20 years, he's been incarcerated for the entire year. That means he's been arrested an average of 3 times a year since he reached his 18th birthday. That's almost a record even for Fulton County. There's not even been an attempt to justify a UJR or any reduction or change to the bond. The state is opposed to any change to the bond. He is a direct threat to reoffend. In fact, he's a certainty to reoffend when he's eventually released from confinement. And he's a threat to law enforcement, especially, the fabric that protects society. Judge, the state is opposed to any change in any lowering of the bond. If the court is inclined to change the bond, the state would request a bond of not less than $250,000 on the obstruction of a law enforcement officer and not less than $10,000 with criminal trespass.
I'm still trying to pull up Odyssey to see exactly what it was.
Your Honor, if I may.
Go ahead, Ms. Beck.
I understand that the state can't justify a UJR. However, can the state justify why Mr. Wilson has not been indicted in, I forget exactly how many days, but almost a year? Thank you. I appreciate that, Judge Manning. So I was hoping that the state would be able to justify why he hasn't been indicted if he is such a risk to reoffend, if he's such a risk to society, our very fabric of society that's protecting us. If he is such a risk, why has he not been indicted in 344 days?
is the Clayton Center, is that inpatient?
I believe it's outpatient, Your Honor. He has been in constant communication with them his entire 344 days that he has been there. There's nothing to me that can justify why the state has not indicted him if they are so confident in their case. He cannot continue to sit there. He does have MH. Wright Street is surely not helping. In fact, I would offer it's making it much worse. They always have the opportunity to arrest him again and indict him. That is always a chance.
All right, let's see. No drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Stay away from 556 Northside Drive. This is obvious, but no further violent contact with law enforcement. Stay out of Fulton County except for seeing your lawyer, court, or mental health treatment. So you must enter the Clayton Center, I guess that's MH program, participate, and follow all recommendations. And of course, now they're updating Odyssey during Orca, of course, so it's not coming up.
That's very helpful.
Yeah.
Did you need a name? Is that what you were looking for?
Well, I'll tell you, what if I do 2002, the sheriff's program?
Can't afford it, but we will file another bond motion.
Well, let me do 1,000 through the sheriff's program.
Thank you, Your Honor.
That's 10%, and I'm going to put that in my email this evening. Thank you,
so
sir.
much.
You can leave the booth.
Judge, he had 2 counts. Is that, or one of them was
Oh,
UJR?
the other one's already a UJR. Yeah.
Okay. All right, so it's
Yeah.
1K or a 10% sheriff program, correct?
Yes, ma'am. All right, Damonte Crowley.
Your Honor, may I be excused?
Yes, ma'am. Have a good evening.
Thank
Damonte
you, you too.
Crowley. All right, there we go. Number 1, Bostic 23, CP 224366, 91 days without indictment, no bond as of December the 23rd. Got robbery, battery, family violence, battery, driving, improper erratic lane change, driving, hit and run, duty of driver to stop and return to the scene of an accident, DUI less safe, driving, open container, possession of marijuana less than an ounce. Free.
10 cycles. Conviction for false part of a crime, November of 2023 for 12 months of 2016 burglary. 1 arrest for probation violation. Open CWAC case, 3 counts. 2 CWAC charges and a battery. 23 CP 224367, then an aggravated battery, 23 CP 218059. And then there's a 2019 theft by taking, battery, family violence, and battery conviction. Nothing further.
All right, go ahead, Ms. Strong.
Thank you, Your Honor. Mr. Crowley is 31 years old. He's a lifelong resident of Atlanta. He's had the same address where he's resided with his mother and grandmother on Catherine Street in the city for over 20 years now. He has 2 children, a daughter and a son. He is a 2008 high school graduate of Creekside High School. He has 6 brothers who currently live in Atlanta. He has a lot of family in the area. He is forklift certified, and at the time of his arrest, he was working at Flower Warehouse. As you heard from pretrial, Mr. Crowley does have another recently indicted case that's going to hold him in for a bit. So we are asking for bond on this case. The allegation of robbery was that he took a Uber driver's cell phone. So we are asking for $5,000 on that charge and $1,000 each on the remainder of the misdemeanors, with the exception of the final misdemeanor, which I don't have my calendar up right now.
Marijuana less than an ounce.
Yeah, a UJR on that one for a total bond of $11,000.
All right, go ahead, Mr. White.
I have no explanation for why this was not indicted, especially as his other case was. But Judge, the state would request that any bond the court is inclined to set include a strict provision that this defendant not use Uber, or not contact Uber, not have anything to do with Uber, and that there is a strict no driving provision attached to the bond. Other than that, the state just requests the court set a reasonable bond under the circumstances.
All right, no drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Stay away from 3054 Waters Road Southwest. No further contact with Keishona, Keishona Harris. And there's Miss Harris on the line, but she doesn't have audio. Miss Rivera, did Miss Harris want to talk?
I'm not 100% sure. She was trying to connect.
Yeah, but she doesn't have audio. Now she has audio. Miss Harris, would you like to say something? We're hearing this case. Would you like to say something? If you do, you need to take yourself off mute.
Hey, can you guys hear me now?
Yes, ma'am. If you can raise your right hand for me. Do you swear a firm testimony you're about to give is the truth, whole truth, nothing but the truth?
Yes.
All right. If you state and spell your name for me, and then I'll hear from you what you need to say.
Keishona Harris is spelled Keishona. Last name is Harris.
All right. Go ahead, Miss Harris. What do you have to say about bond?
Okay. I am for bond.
Okay, he's going to get a bond, so
Okay.
What? Anything else?
Another thing is because I had told the officers and all that he was supposed to be getting charged with any type of family violence with me because of some reason it was a lot going on that night with him and my mama boyfriend, and it was a lot of fighting going on. As far as that robbery, that was never supposed to be getting charged as well because it was no robbery. Because I know on thing he was a little bit intoxicated that night.
All right. Any questions, Ms. Strong or Mr. White?
None from the defense, Your Honor.
All right. Thank you, Ms. Harris. All right, no drugs. I think I already said that. No drugs, no alcohol, no weapons, no replicas of weapons. Stay away from 3054 Water Street Southwest. No further contact with Keishona Harris. No further contact with Anthony Preston. No further contact with Stephen, Steven Felton. No driving unless your bond is modified. You cannot use any ride share, Uber, Lyft, or I don't know, any other ride share if there's more than that out there. Also, if available, you have an income monitor paid for by the county with a 24-hour curfew, court, lawyer, and medical. Court, lawyer, and medical. All right, so we'll do 10,000, 5,000, 10,000, 5,000, 5,000. 5,000. UJR jail, UJR jail. That's 10,000, 5,000, 10,000, 5,000, 5,000, 5,000, UJR jail, UJR jail. Best of luck to you, sir. You can leave the booth. All right, Sean Eason. Number 8, Bostic, 23 CP 220375, 244 days without indictment. There's a $3,000 good bond as of November the 29th on battery and criminal attempt to commit a felony. Free trial.
This is only prior arrest.
All right. Oh, there, go ahead, Mr. Go ahead, counsel.
Thank you, Your Honor. Mr. Eason is 26 years old, lifelong resident of the state of Georgia. As you heard, this is his first arrest. We've been working to get him into a program, but we had been hoping to procure the services of the bail project to get him bailed out. He doesn't have any family that's going to be able to help him bail out at this time. And so, Your Honor, we would be asking that the bond be reduced at this time from $3,000 down to $1,000 or a UJR if Your Honor is willing to consider a UJR in this matter.
Does he have an address where he'll live?
Not presently, Your Honor. We are still working on securing him housing.
Okay, go ahead, Mr. Wright.
Good. Hang on, I'm just trying to see what the it's an attempted robbery.
Yeah, it looks like the robbery by sudden snatching was dismissed.
And so we have an attempted I'm trying to understand. Oh, okay, I see. He didn't actually get the purse, so. Well, I don't know if attempted robbery is bail restricted or not. I'm reading the statute. Robbery would be, but.
Let's see. No, I don't know if attempted is.
Mhm.
I'm looking at my little list here.
Yeah. Judge, the state would not oppose a bond reduction or UJR as long as one of the conditions is that he be transported directly from the jail to somewhere that's going to provide him some stable housing. In the absence of that, the state is opposed to any reduction in the bond, nothing further.
Does he need MH or addiction treatment?
Your Honor, we are not sure about MH. We don't believe so. Certainly no to addiction.
Okay. All right, let's see. No drugs unless prescribed, no alcohol, no weapons. Stay away from 240 South Main Street in Alpharetta. No replicas of weapons. Must supply an address upon release. No further contact with Sarah Joseph. I'm gonna do UJR through the jail and then 500 through the sheriff's 10%. Because I don't know, according to the statute, if it's bail restricted or not. A UJR and then 500 through the sheriff's 10% program. Best of luck to you, sir. Michael White. All right, number 2. 23 CP 224388. 91 days without indictment. There's a $135,000 good bond as of January the 12th. I got aggravated assault, possession of a firearm by a convicted felon, criminal damage to property in the second degree. It looks like, has something been dismissed? Because on this counter, it just has 4 charges, but there's 6 on the previous bond order. Has something been dismissed? Ms. Strong, do you know?
Let me check now, Your Honor. Give me 1 second to look at Odyssey.
Yeah, mine's still like trying to come up because it said it was updating, but I don't.
There are only 4 charges in Odyssey, and I don't see any order of dismissal, so I'm not sure.
Well, if you want, we can we'll talk about all 6 just in case. I don't know. Sometimes Odyssey, it's not being updated yet, but all right. So it's what it is on the previous bond in January is ag assault, possession of a firearm by a convicted felon, criminal damage to property in the second degree, criminal damage to property in the first degree, and possession of a firearm during the commission of a felony. Pre-trial.
Cycles, misdemeanor, possession of firearm, pistol by someone underage. Open case 23 SC 191295, trafficking a meth firearm during firearm by theft by receiving cocaine. And signed a Judge Cobb. The felony conviction is from 08.
All right. Go ahead, Ms. Strong. And do you know where he'll live?
Yes, I do, Your Honor. He will reside at 50 Mount Zion Road in apartment F39 in Atlanta. That is in Fulton County. He'll reside there with his girlfriend, Deanna Williams, and his cousin. He's 34 years old. He's a lifelong resident. He has a lot of family in the area. He's a 12th grade graduate. He went through the 12th grade and also received his GED. I'm sorry, it's my dog.
That's okay.
He received Social Security disability for some MH issues. He has an 11-month-old daughter that resides with him. We're asking for a reduction in bond. I didn't know about the additional 2 charges. I only have the 4. So we were originally requesting $20,000 on each aggravated assault, $10,000 on the gun charge, and $5,000 on the property damage for I believe that's $55,000.
Mr. White, and do you see anything else? Because the bond order of December that now came up has 6, but like I said, the calendar only has 4.
I'm looking, Judge. I see the same thing, but I only see 4 charges in Odyssey. I'm not sure why the bond order
He was only in with the first four at first appearance. Maybe during his prelim, they added two counts.
Oh, that could be.
That's possible. So we would ask for 10 on the firearm by a felon. And what was it, first degree property damage?
First degree and second degree.
So it was 5,000 I asked for on the second degree, so I'll ask for 7,500 on the first degree.
Okay, go ahead, Mr. White.
Judge, there having been no even mention of any change in circumstance that would justify a disturbing the bond order from, well, 90 days ago. And given the fact that he does have another pending case in front of Judge Cox, 23 SC 191295, that involves mandatory minimums of 10 years confinement. Certainly it is the state's position that any reduction would be inappropriate. Were the court inclined to modify the bond, the state would request that the bond actually be increased to a much more appropriate bond, given the dangerousness of this offense, given the fact that he has a pending firearm offense that involves use of a firearm or possession of a firearm during another felony. And this is that now his second possession of a firearm by a convicted felon. State would request a bond of not less than 100,000 on each of the aggravated assaults, not less than 50,000 on possession of the firearm by a convicted felon, and not less than 20,000 on the criminal damage, not less than 20,000 on each of the other two, just provided that they are actual charges that
They were made during the prelim by Judge Drake on.
Okay. So for a total bond of, I think that's 200,000 if my math is right.
All right, let's see. No drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. You have an ankle monitor available, paid for by the county with a 24-hour curfew, court, lawyer, and medical. I think in here, well, still not pulling up. Looks like you allegedly shot at people in a car. No further contact with Morgan Medlock and Ashley Gales, Gales. Stay away from 4001 Lakemont Drive in College Park, Georgia. Let's see. So 25,000, 25,000, 20,000, 5,000, 20,000, and 20,000. It's 25, 25, 25, 20, 20. Best of luck to you, sir. Good lay the booth. Davon Jamerson. All right, number 6, Bostic. 23 CP 223652, 119 days without indictment. $25,000 good bond as of December the 15th. Purchase, possession, manufacture, distribution of marijuana, possession of a firearm or knife during the commission of a felony, receipt, possession, transport of a firearm by a felony first offender, driving license suspended or revoked, knowingly driving motor vehicle and suspended, canceled, or revoked registration. Free.
12 prior arrests, 1 FTA battery family violence in 2020, criminal attempted a felony in 2017. Sentenced in 2017 for 7 years probation. There's a 2019 firearm by a first offender. Sentenced in 2019, 5 years probation. 5 arrests for probation violation. Nothing further.
All right, go ahead, Mr. Hines.
Thank you, Your Honor. Good evening.
Good evening.
Mr. Jamerson's a 25-year-old man. He's lived in Atlanta over half his life. He and his partner live here in Atlanta, have for years. They live with their 3-year-old daughter. Mr. Jamerson receives disability and is able to financially contribute this way, and I'll speak more about why he's on disability later. Mr. Jamerson received his current bond of $25,000 over 3 months ago in mid-December. Then he had been in 20 days. Now it has been 119. 119 days in which he's been subjected to indignities hardly anybody on this Zoom can imagine. 119 days in which he has been jumped multiple times and stabbed multiple times. As you heard, only 2 previous convictions, only 12 cycles. His first cycle, as I'm sure the state will give you some math, his first cycle was when he had just turned 18. That indictment accuses him of criminal attempt for throwing a football at a window. I'd submit that's the most serious charge he's had. If the state tries to harp on his very short, very mild history that's almost devoid of convictions, I'm assuming, like last hearing, it'll talk about him having a previous charge similar to one of the charges today. But it's not a violent charge. And please, briefly, let's consider the nature of the allegation. Mr. Jamerson, I want to be absolutely clear. He's certainly not admitting to knowingly having a gun around him. Mr. Jamerson is absolutely looking forward to his day in court, including a motion to suppress hearing that we're going to try to have based on piecing together what happened, since of course the officer said and our subpoena revealed that his body cam was lost. Again, Mr. Jamerson vehemently denies these allegations. So let's just talk about the charge on his face. Mr. Jamerson lives on Godby Road. I don't know if anybody on the Zoom has been to Godby Road. He was shot 3 months before these allegations arose. In this country and in this state and in this city, the law hasn't quite reconciled this country's almost unfettered and unlimited love of gun ownership rights for everybody. They haven't reconciled that with the fact that many convicted felons need to be protected also. I repeat, Mr. Jamerson did not know the gun was there. He vehemently denies these allegations. He vigorously awaits his day in court. But whoever's car it was probably needed a gun to protect themselves on Godby Road just as much as he does. That being said, what do we have here? Very few cycles, even fewer convictions. A case that smells heavily of a motion to suppress. It smells heavily of rebuttable presumptions. Beyond that, Mr. Jamerson has strong ties to this community, with much of his family being here, beyond his partner and his daughter, whom he doesn't have the means, desire, opportunity, or thought to flee from. He's desperate to get out to his daughter, to his partner, Miss Brown, who is on the call, and back to his life. After an unconscionable 3 months trying to make this bond and over 4 months incarcerated, we are humbly asking for a bond of $3,000. Thank you.
All right, go ahead, Mr. White.
I personally would like to believe that that the most serious part of his first felony conviction was throwing a football, but I just strange credulity to me to even consider that. Judge, this defendant has picked up one arrest every 8 months since he turned 18, including multiple arrests for possession of a firearm, multiple arrests for possession of a firearm after his first conviction. And to characterize his criminal career as being light or as being nonviolent or as being, I don't know, worthy of a medal and a cup of coffee, is just, well, frankly, disingenuous at very best. Judge is a very dangerous individual. He's certain to commit another felony as soon as he is released from confinement, because he will eventually be released from confinement on these offenses. Judge, the state is opposed to any change lowering of the bond if the court is inclined to change the bond at all, certainly an increase of the current bond by probably about tenfold would be the appropriate action for this court at this point. Nothing further.
All right, no drugs unless prescribed, no alcohol, no weapons, no replicas of weapons, no further contact with Alantra, Alantra, Eccles, ECHOLS, no driving unless your bond is modified. Let's see. What's 59 grams of marijuana, so I'll do 1,000, 10,000, 10,000. 500 and 500. Best of luck to you, sir. You can lead the booth.
Well,
Edgar,
thank you. May I be excused?
Yes, sir. Edward McDowell. All right, Bostic number 3, 24 PI 000552, 149 days without indictment, no bond as of January 24th. Got aggravated assault and possession of a firearm during the commission of a felony.
28 prior arrests, at least 4 felonies, 5 arrests for FTAs, open cases, 2 with Judge Lethbridge, 19 SC 168930, aggravated assault, family violence, firearm during, firearm by, 19 SC 168921, aggravated assault, family violence, entering, auto theft, terroristic threats, criminal trespass, death by taking, which is in judicial hold, open 23 CP 222913. Ag assault, battery, family violence, firearm during, firearm by, aggravated battery, 23 CP 222914, schedule 2, firearm by and giving false name. There's a battery, influence, witness, terroristic threats and acts, stalking conviction from 08, nothing further.
All right, go ahead, Ms. Strong.
Thank you, Your Honor. Mr. McDowell is 57 years old, another lifelong Georgia resident. I'm covering for Mr. Rogalski tonight.
I just noticed that. I was like, whoop, yeah, go ahead. I'm sorry.
That's okay. He was living at 2555 Donald Lee Howell Parkway in Atlanta. He has completed the 9th grade and he has 18 children, the youngest of whom is 10 years old and the oldest of whom is 42 years old. We acknowledge that the history is not great and that he is being held in on some other charges. So we are asking for 20 and 10 for a total bond of 30.
Okay, go ahead, Mr. White.
Yeah. He has 4 pending family violence. And then this one that I was just trying to look up and my Odyssey is down. So I'm having your problem.
Updating it.
Yeah, no. And so I can't verify whether this particular ag assault is also a family violence. He's not a good risk for bond under any circumstances. And certainly not a good a risk for a reduction of the bond.
I believe he's currently in no bond.
After 141 days, no,
Yeah, 149. Yeah, it's no bond.
Why would you not get this indicted is frankly beyond me. Judge, the state would request a strict stay away, no contact with the victim. 24-hour curfew. I don't know if it's possible for us to prioritize this individual as somebody who really, really needs an ankle monitor. But yeah, what we really need to do is indict him before he was entitled to a bond, but we failed to do that as the state. Judge, the state, I have no choice but to leave it in the discretion of the court. We'll ask for the strict stay away and that if possible to prioritize him as fitted for an ankle monitor, that the court make that part of its order, nothing further.
All right, no drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Stay away from 2400 Campbellton Road, apartment M as in Mike 10. No further contact with Jared, Jared samples. Also stay away from 2343 Campbellton Road. Available, you're gonna have an ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical. That's the only reason you leave your house. Court, lawyer, and medical. Your 18 children can come and see you. And it's still spinning. So 40,000 and 20,000. Best of luck to you, sir. You can leave the booth. So, Ms. Strong, I don't see Jordan Indige.
That case is an anomaly, Your Honor. So that I'm not sure why it's on this calendar, but I do need to discuss it. So he received a UJR level 1 through when he had his case last year. He has requested a modification of bond conditions in order to take his wife to Jamaica for her birthday this May. Pretrial is requesting that it be put through by the court in order for that trip to happen.
Is he still out on pretrial? I thought it was only like 100 and how many days? 120 days?
4 months, Judge.
I'm not sure.
Yes, it's 120 days. It should be over. It should be at 130 something days because he got out around the same time as the other lady. He got out November 28th of 2023.
You got any problem
taking off pretrial?
You got any problem, Mr. White, as long as he supplies the itinerary?
Yeah, I do actually. It's international travel. Tough to bring them back if they decide not to come voluntarily. The state's opposed to allowing international travel from someone who's currently on bond. Nothing further.
Well, it's disorderly conduct in Schedule 1. Bostic, what was his criminal history?
Couldn't be much if he got a signature on the pretrial.
Well, all right. Submit the itinerary, Ms. Strong.
It's in the bond motion, but I can send it directly to you, Your Honor.
Yeah, just submit the itinerary and the order will allow him to do it. He has to supply all of that. Thank you. What about, let's see, Albert Jackson? Yes, ma'am. Albert Jackson. And he doesn't have audio, Mr. Dobbs. 23 CP 224542. Marijuana less than an ounce, possession of Schedule 2, possession of Schedule 2, possession of Schedule 2, and drug-related objects.
Nothing new to add. He got out January 2nd, 24. He's compliant on a split pretrial bond. Nothing further.
All right, go ahead, Mr. Dobbs. He's still not
Thank you,
connected to audio.
Okay. I'm just gonna go ahead and make my argument. Mr. Jackson has he was set a bond of $50,000, which he made via a property bond, which is worth nearly 4 times that amount. Odyssey has it listed as $190,000. So that's almost 4 times the value of the bond that was posted for him at first appearance. We all know bond is not meant to be punitive. The purpose of bond is to secure Mr. Jackson's presence at court. By posting a property bond nearly 4 times the amount of the bond, my argument is that of course makes him having to submit to the pretrial services punitive, because the state has what it needs to secure him to his next court date. As pretrial stated, he has been compliant in the about 3 months that he has been on pretrial services. There's been no issues there. So for those reasons, we ask that the pretrial services be removed from this case, and that it be a regular UJR. I'm sorry, a regular $50,000 bond covered by the property bond that Mr. Jackson posted. Thank you.
Go ahead, Mr. White. I mean, he's level 1, right, Bostic?
He's level 1, and it looks like the pretrial is just on the misdemeanor charges. And it's going to expire.
Right. It's just on the misdemeanor. He paid cash. He paid a bond on the other charges.
Yeah. The pretrial supervision is going to expire in 28 days. I'm not sure. I think that's 1 phone call from now, unless I'm mistaken.
Correct.
I'm
What
not
is
sure.
his request?
We're asking for those UJRs with the level 1 to be converted to UJR jails.
I'm not sure why we're taking the court's time.
Yeah, I mean, he's got 28 days. So after it, if they don't have an objection, if you want to make sure he's off pretrial when it's 100 and in another 28 days when it's over, just send an order. And
Judge, he shouldn't have been on pretrial, and I don't see no reason not to take him off pretrial. It's just on a misdemeanor. He paid a $50,000 bond to get out.
Yeah, I know. I didn't do it, but it's 20 more days.
I get that.
Yeah, I didn't set it, and I can't pull up and look at anything because they want to update Odyssey while I'm working.
I mean, he's been compliant. If they want him off pretrial, and if his case manager sent for him to come here, then take him off pretrial.
Do you see any notes in there, Bostic?
Yes, that he was compliant.
What is he doing? Calling in once a month?
Yes, it used to be the first month you have to be like everybody's like level 3.
Right.
Or he had to appear in person at first.
Right. Sorry, I got my little cheat sheet out here. All right. There's just 20, it's just a pain, I guess, for him to call. All right, just remove those. It's just marijuana, less than ounce, and drug-related objects. You just make it UJR jail.
Thank you, Judge Manning, and thank you, Ms. Bostic. That concludes my business for the day. I will send you a order for that, Judge. Thank you. May I please be excused?
Mr. Dobbs, are you Charles Peck and the Charles Peck case?
Mr. Peck is released.
Okay. And with it was a bond modification, so
that was filed before that. I'm withdrawing that. It's moot.
okay. What about, let's see. Yep. Okay. Thank you. And I guess Mr. Scarborough is not here for Adams because Adams isn't here.
Mr. Cazzoli did want me to make one announcement that he thinks you are aware of, but he wanted to say that the Nickens case has been resolved.
All right. Thank you. Mr. Jackson, you can go ahead and leave. Mr. Dobbs will get me the order.
Thank you.
All right. And I guess on the Scarborough one, that was off. So we just got Jillian Cunningham. Ms. Cunningham, if you will start your camera. All right, last one. Let's see. It is number 6 on the bond modifications. 23 CP 221, 222188. Possession of Schedule 2 controlled substance, possession of Schedule 4 controlled substance, possession of Schedule 4 controlled substance, possession of Schedule 4 controlled substance, drugs not in original container.
Been out since September 29th. Nothing new to add.
All right, go ahead.
Thank you, Your Honor. Ms. Cunningham was released, as you saw, in September of last year on UJRs for these drug-related charges. Ms. Cunningham, in that time, she was fitted with an ankle monitor and has also been participating in the Sober Living America rehab program up in, I believe, Cherokee County. Your Honor, in that time, we had one motion to modify bond conditions. She has a 24-hour curfew as well. We had one motion to modify bond conditions that we were able to reach a consent over to allow her to participate in certain activities that are required by the Sober Living America program, including attending school events for her son, who's in middle school at Mill Creek Middle School. He also plays basketball up there. She sometimes is able to go to basketball games and spend 1 to 2 nights a week out, Your Honor. But it has been about 6 months now that Ms. Cunningham has been out actively participating in the program. She will continue to go through the program. It's a inpatient program, so she is going to continue to reside there. And Your Honor, at this time, we're asking for the ankle monitor to be removed and for the 24-hour curfew requirement to be lifted, so that Ms. Cunningham is commensurate with the program. As she continues complying with the program, she's granted more and more freedom over time. And is actually encouraged through the program to go out and foster these social connections she has with her family, not just her son. She has a great relationship with her parents, Mr. and Mrs. Cunningham. They're present on the call today as well. That's Tom and Carolyn Cunningham. Your Honor, she's been totally compliant with the ankle monitor, totally compliant with everything required from her from Sober Living America. We also have a letter from the program director describing her as a model guest, a model participant of the program. And so for those reasons, Your Honor, we would ask that the ankle monitor be removed. It's my understanding that taking the ankle monitor off Ms. Cunningham today will allow another one to be placed on a perhaps more worthy candidate.
All right. Go ahead. What's the criminal history previously, Bostic?
One moment.
Now
It's probably nothing since she got a signature bond through the jail.
do you see it, Mr. White?
I don't show any prior criminal history. And as it turns out, I am familiar with at least the Gainesville Sober Living America program that was used to usually good effect by the drug courts up in North Georgia. Judge, I really don't see why we have an ankle monitor on someone who's in the inpatient program at Sober Living America. It seems redundant, to say the very least. The state would have no objection to the requested modification as far as removing the ankle monitor.
I think some people just started copying me after a little while.
Yeah, okay. Yeah, there'd be no objection from the state. The state would request that the 24-hour house arrest be modified so that the only exceptions would be those exceptions that were a requirement for her participation in the Sober Living America program. Nothing further.
All right, there's mom and dad. Mom and dad. Mom and dad, do y'all want to say anything? You know, take yourself off mute. Do you want to say anything? Because you're on mute. I can't hear you. You're on mute.
Okay, can you hear me now?
Yes, sir. If you want to say something, if you raise your right hand, you swear affirm testimony you're about to give is the truth, all truth, nothing but the truth.
Yes.
Okay.
The only thing that I'd like to add is we get to speak with Jillian almost daily, and she gets to spend a night here every once in a while. We are about 20 minutes away from the residency. And there's been so many times that her mom and I have said, why don't you come out to eat with us, or why don't you come to church with us? And she keeps reminding me that she can't because of the monitor. And she's not angry about it. She's very patient. She knows someday it's going to come off. And so I'm looking forward to having her be able to join us for more family events.
Okay. All right. Yeah, like I said, I still can't pull it up. Thank you, Mr. Cunningham. I appreciate it. And Ms. Cunningham for being here. I mean, I don't know why it was on there either. I can't really speak to that, but we can remove it. But I still want her to, and when I say have a curfew, ma'am, and Mr. you can make the curfew like this. Like, you know, this is inpatient program. So as long as she's there, unless she's participating in the program, I'm not going to keep you away from your child, especially if you're building a great relationship with them or your parents. But I want you to remember that your parents are always your parents. You're still a kid until both your parents are gone, and you're obviously still a kid because your mom and dad are both here. So if they see you, I'm hoping if they see you doing something that you shouldn't be doing, or that may be testing your sobriety or putting it, in jeopardy, hopefully you will just listen to what they say. All right, because like I said, you're still a kid until both of them are gone, and you're very lucky that you got both of them still here, so they're still your parents. All right, so you can modify that, council, like the 24-hour curfew, with the exception of like things with their kids to go see, as long as she just lets you know where she's going. So, ma'am, that doesn't mean you can't go to the grocery store. It means you just can't go out and hang out with friends just because you want to go hang out with friends. Okay, because I want you to really comply with that program and keep doing what you're doing. All right. And I'm gonna put it on your parents to make sure that if they think you're going astray, they're gonna reach out to your attorney, and we're gonna try to tighten it back up, okay?
Okay, thank you.
All right, thank you, Mr. Cunningham. You can just shoot that to me, counsel, and you can, things with their children, visit her, as that, if she's not participating in the program, seeing her parents and do more, she can go to all the game. It doesn't matter, just as long as she's not drinking or drugging.
Here, Judge. Good afternoon, Judge Manning.
Hey, how are you?
I'm here.
Hey, Beck. All right, we'll start with number 4, James Hodges. All right, we got 24 PI 004157, 101 days without indictment. $9,000 good bond as of July the 5th, 2024. Willful obstruction, felony, simple battery against a peace officer, and simple battery. Pre-trial.
13 cycles FTA in 2017 and 16 of battery, family violence, and 2013 open to drug-related objects. Nothing further.
All right, go ahead, Ms. Beck.
Thank you, Your Honor. Mr. Hodges is 34 years old. He's lived in the metro Atlanta area for the last 14 years. He was supposed to start working at a valet right prior to his arrest, but he's hopeful that he'll be able to get back to that. He is a high school graduate and then also attended 1.5 years of college. We would be asking for a bond not to exceed $3,000. He has been meeting with our social worker, and they're trying to get him into a program. However, we need the bond to be low enough so that we can make both of those things happen simultaneously.
All right, go ahead, Mr. White.
This defendant has been in, as the court noted, 101 days. The last order for bond was July the 5th of 2024. No. Yeah. Which is, what's that, 96 days ago?
Right.
Something like that. And that was a bond reduction. There's been, other than the fact that he'd like to get out and get, somewhere other than jail, I haven't heard anything that there's been any change in circumstance at all or any reason to disturb the bond. Perhaps if the defense had a place for him to go or had a firm commitment or, transport order or something, that might be something we could deal with. But at this point, he's been in really only 100 days. The state still has almost 900 days, almost 1,000 days before, actually over 1,000 days before we need to get this case indicted because he already does have a bond. There is no reason to disturb the bond. And given his history of failures to appear and his criminal history at all, $9,000 is charitable, to say the very least. Nothing further.
All right. No drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Stay away from 1000 Piedmont Avenue. Stay away from all Caribou coffee shops. No further contact with Nathaniel Dalton. I'll do 3,000, 2,000, and 2,000. Best of luck to you, sir. All right, is that it for you, Ms. Beck?
I believe so, because you said Mr. Lindstrom and Mr. Murphy were both indicted.
Right.
Yes, may I be excused?
Yes, ma'am. Have a good evening.
Thank you. You too.
All right, now I got John Davis. All right, let's see. I'm taking a second. All right, I got position 7, 24 PI 003044. As of June 27th, there's a $1,000 split bond on possession of Schedule 2 controlled substance and drug-related objects. And looks like he's been in 138 days without indictment. Pre-trial.
18 cycles FTA in 22, burglary in 2018, given false name in 23. Nothing further.
All right, go ahead.
Your Honor, my name's Jessica Gerber. I am one of the new attorneys with the Public Defender's Office here. Recently took over for Mr. Rogalski and wanted to just introduce myself quickly. Mr. Davis, I just met with him.
Can you hear her, Miss Bosky?
I can't hear her, Judge.
Yeah.
I can only hear her very softly.
Yeah.
About that.
There you go. When you lean up, I can hear it.
Okay, I'll just lean on in.
There you go.
He is in his 40s. He is 40 years old. As we heard from pretrial, he does have a couple cycles that he's facing. Currently, my understanding is that he is up against not having an ID, and that has been a barrier to him being able to become housed. So he has been really trying. Most recently, he was arrested just looking for a place to sleep, unfortunately, really close to where we're at in Atlanta. And so even though where we're at here at the 100 Peachtree building, actually, and so even though he has only been in, he hasn't quite gotten to a 90-day mark since the initial bond was consented to, we would ask that Your Honor consider something nominal in his case. He has unfortunately not been able to work. He's certainly open to some type of rehab program, but because of his lack of an ID, which I will work with the social worker to get rectified as soon as possible, but that has limited us in our resources. However, we do believe that given his insecure housing, Your Honor, that he would be able to make it back to court. He stays around this area, and we believe that a nominal bond is sufficient to meet the purposes of bail, given that Judge Brooks determined that he was bail eligible back in June.
All right, go ahead, Mr. White.
Judge, this is a consent bond, and it's a consent bond from, I believe, June 27th of 2024. And it is, in fact, a nominal bond. It's a $1,000 bond. Doesn't get much more nominal than that. So he has everything that the defense has requested, and he has everything that the defense agreed to. There's been nothing to show that there's been any reason to disturb that agreement. And given his history, given the fact that the current policy of the Superior Court is that if someone is unhoused, as my learned colleague put it, then they will not issue bench warrants or otherwise attempt to bring the person to court. Simply, they'll put the case in judicial hold, and the person continues to drift if he doesn't appear in court. Therefore, it is extremely unlikely that if he is released just to the street, literally to the street, we will never see him again until, fortunately for the state and for the people of Fulton County, he commits felonies frequently enough that it'll probably only be a year or so before he's back before us with a new felony, and then we can hopefully deal with this one as well. Judge, $1,000 bond is what was consented to. There is no reason to disturb the bond. There is no reason to disturb the consent. The state objects to any lowering of the bond. And since the state did consent, the state will not request to raise the bond at this time, although that would certainly be the appropriate action, nothing further.
It does look like previously it was on a pretrial and they surrendered. Am I right, Bostic?
This was a pretrial surrender, Judge, which is why there's a consent from June.
All right. So no drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Must supply an address where you'll be living upon release. $900, and all you leave the second count at UJR through the jail. Best of luck to you, sir. Is that it for you, ma'am? Or you got?
Yes, Your Honor, that completes my business. May I be excused?
Yes, ma'am. Have a good evening.
Thank you, Judge.
All right, I got Zatar Hunt. This is Kennebrew. All right, so we got position 8, 24 PI 004231, 99 days without indictment. There's a $15,000 good bond as of July it's a $15,000 split bond as of July the 8th, 2024. Use of communication facility and committing crimes. BGC, possession of controlled substance in Schedule 1 or 2 is 5 fentanyl pills. With intent to distribute, possession of controlled substance in Schedule 1, possession of controlled substance in Schedule 1. Rah.
6 with the U.S. Marshals, conspiracy to defraud in 2017, probation violations, possession of firearm in 05 Georgia, 25 cycles, cocaine with the intent that's old. IM, that's from 07, FTA in 24, 23, and 02, nothing further.
All right, go ahead, Ms. Kennebrew.
Yes, Your Honor, thank you. Mr. Hunt is 43 years of age. He does have a valid address here in the Metro Atlanta area where he resides with his wife of 14 years. He is from Georgia, so he does have ties to the community. He did attend Washington High School and he graduated in 1997. He was working prior to being arrested at a cleaning services for over 2 years doing commercial cleaning. He also has a child that does reside with him. We would just be requesting that the bond is lowered. He has been in custody. His bond is currently $15,000. We'd be requesting that bond be split in half to $7,000.
All right, go ahead. Oh, is he gonna live in Fulton County?
Yes, Your Honor.
He doesn't live at the 2451 Old National Highway, does he?
No, Your Honor, not at that address.
All right, go ahead, Mr. White.
Judge, as the court pointed out, this was a bond that was granted July the 8th of 2024. Given the quantity of Schedule 1 narcotics here, certainly 15,000 is a very low bond. He's only been in for a little over 100 days, meaning that the state has more than 1,200 days to indict the case before there's any problems with the indictment now that this defendant has a bond. Therefore, there is no reason to disturb the bond. It's not like he's been in for an extended amount of time, and it's not like the state has not been diligent or is in danger of violating the statute of limitations. Judge, given the fact that he does have 6 cycles with the federal government and 25 cycles with Georgia, including FTAs in this year and last year, he is a very, very poor risk for bond. The state's position is that there is no basis for reducing the bond. In fact, a more appropriate action for the court would be to go $15,000, minimum of $15,000 on the use of communications facilities, a minimum of $15,000 on the Schedule 1 or 2 with intent to distribute, and then a minimum of $10,000 each on the remaining 2, which would be a minimum of $50,000 bond. That would be much more appropriate in this case. I won't address the fact that the IALA factors mitigate against any bond at all. Nothing further.
If I may respond, Your Honor.
Sure.
Bond is not to keep the accused in custody. So the state, while the state may have over 1,000 days to indict the case or to move the case, the client is not to be held in custody for 1,000 days while they decide whether or not to indict that case. Bond is simply to ensure that my client will return to court and will appear for his court appearances. We don't know the factors behind the FTA, so I won't go into that, but we would just like for the court to keep that to take that into consideration and to keep that at the forefront as well. Thank you.
No drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Stay away from 2451 Old National Highway. You say he's going to live in Fulton County, right?
That is correct, Your Honor.
All right, so I'll leave it at UJR jail, 5,000, 4,000, and 4,000. Best of luck to you, sir.
Thank you, Your Honor. And that concludes my business with the court. May I be excused?
Thank you. Yes, Ms. Kennebrew. Good to see you.
Good to see you as well.
All right, I got
I'm sorry, Judge. I don't mean to interrupt. I have a quick question for position number 7, Davis. He also had a
who?
A UJR through the jail. Mr. Davis, position 7.
I believe the misdemeanor was a UJR through the jail.
900 and then a UJR through the jail, right?
Okay, thank you. We're completed here. DC.
Thanks.
Thanks.
All right.
Bye.
What about Latif Ferbert? Wave your hand if you're Mr. Ferbert. Nope. We got Michael Edge. There we go, Michael Edge. All right, we got position 3, 24 PI 004130, 102 days without indictment. There was an $80,000 split bond as of June the 11th. Ag assault. Yeah, 3 ag assaults, possession of a firearm or a knife to the commission of or attempt to commit certain felonies, battery, cruelty in the third. Michael Edge?
Position 3.
Yeah, I got 14 cycles, carrying a weapon in a public gathering, furnishing alcohol and O2, DUI, battery, family violence, and 21 couple of probation violation in the military, wrongful use, marijuana, 6 cycles in Alabama.
That it, Busted?
And there's a battery, family violence, and a cruelty to 30 from 2020.
All right.
Nothing further.
All right, go ahead, Mr. Showalter.
Michael Edge is 40 years old. His address, if release, would be 3571 Clubhouse Circle East, Apartment C, Decatur, Georgia. That is an address with family that the complainant is not residing at. He's been in Atlanta for 14 years. He was previously working as an automotive technician at All Start Auto Lights. He was working there for a year. He's a high school graduate. He is an Army veteran. He served there 2002, 2004. And he's been in over 100 days. So the split bond, he is entitled to a monetary bond on all charges. 80,000 is something outside of the range of somebody who's been incarcerated for months. He's not getting any richer. So I would ask for, they got 20,000 on all the misdemeanors there. I would ask for 5,000 on each charge if we're going to be doing it like that.
All right, go ahead, Mr. White.
Yeah, I'm just.
Excuse me.
Judge, my, can you hear me, Judge?
I can.
Okay, that's good because my Zoom is acting up. I can't see anything right now. So as long as you can see and hear me, Judge.
I still look as stunning as ever, so don't worry about it.
Well, all right. I appreciate that, Judge.
All right.
I have no explanation for why we didn't get this indicted. This is a family violence, and I was unable to research before. I just ran out of time. He has 4 prior family violences on, and then this is actually his 5th.
It's the same victim.
And that's why I was not able to figure that out before. I just ran out of time before I could figure out if it was all the same victim. But Your Honor, it's just, I don't know why it's not indicted. The state would request that the court include with any bond a strict 24-hour house arrest enforced by an ankle monitor. The only exceptions being in-person court appearances and medical emergencies when taken from his home in an ambulance. A strict stay away, no contact of any kind whatsoever with the victim, either the primary victims or the children who are the subjects of the cruelty to children of the 3rd degree.
All right.
Nothing further.
Any victim contact, Ms. Rhodes?
Yes, Your Honor. The victim is on Zoom. Ms. Smith.
Does the victim want to speak, or does the victim tell you something to say?
When I made contact with her, she said it was okay and that the defendant is her husband and she's okay with contact. But last time I talked to her, she said she would not mind addressing the court.
All right. Well, I don't necessarily feel the same way. So we'll have no drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Stay away from 1472 Normanberry Drive, East Point. Stay away from 3478 Washington Road in East Point. And Mr. Dukes, a 24-hour curfew. The only reason, period, court, medical, and to see his lawyer. That's it. That's the only 3 reasons he leaves his house, because he's going to stay out of Fulton County. Sir, do not darken the door of Fulton County unless you are coming back to see Mr. Showalter or to come to court. That's the only reason you come to Fulton County Court, and to see your lawyer. Must supply an address where you're going to be living. No further contact. Absolutely no further contact with LaShonda Smith, LASHAWNDA, Smith, Adrian, ADRIAN, Allen, ALLEN, and Corshawn Smith, CORSHAWN. You will have that county paid ankle monitor with that 24-hour curfew. And sir, mark my words, if you do not keep that ankle monitor charged, or if it sees you leaving your house and you're not at a hospital or seeing your lawyer, your bond could be revoked. All right. So do 30,000, 30,000, 30,000, 30,000, 20, 20, 20, and 20. Best of luck to you, sir. You can leave the booth. Now do I have Latif Ferbert? Wave your hand if you're Mr. Ferbert. Do you see him, Mr. Pete? All right, there we go.
I see him.
All right, thanks. All right, so we got position 1, Bostic 24 PI 000949, 92 days without indictment. Looks like as of April the 22nd, there's a $2,500 good bond. It was a consent bond. And the way it looks, somebody's already posted that bond, Mr. Pete, is on that case for cruelty in the first, simple battery, felony violence, and terroristic threats and acts, or do you show something else?
Judge, to tell you the truth, I just filed an entry of appearance on this case. Miss Parisa Safarina was the previous attorney. I believe she filed this before I filed an entry.
All right. Well, let's see. Bostic, pre-trial.
Second, Judge, I was looking at something with him. 241 0328.
Sorry about that, Judge.
No, that's
Judge, the indicted case is what's holding him in custody, I think.
So has he posted this bond though?
Yeah, it looks like Red Eye Bond is on this case, the indicted case, the 24 SC 004153. And that bond may not be paid, and that's 15, 20, I'm at 30, 35. That's a $40,000 bond on that case. That's
So
assigned to Judge Adams, armed robbery, ag assault, firearm during an obstruction, and a simple battery.
So that is it, Mr. Pete. It does look like he posted that. Sometimes the stuff on there is wrong, but I just,
And because this bond is just $2,500.
Yeah,
that's correct.
That's the red eye bonding made that. So it's the indicted case that's holding him.
Yes, Judge, and I'll be dealing with that.
Okay, so since he's made this one, but if anything comes up, shouldn't, but let us know, we can put him back on, okay?
Yes, thank you, Judge.
All right, thank you. Thank you, sir. You can leave the booth.
May I be excused, Judge?
Yes, sir. Have a good evening.
You too.
So, and Ravello's on next week, right?
That's correct, Judge.
Okay, let's see. We got one more, Mr. Cordes. Hold on. All right, we got Philip Matthews. Mr. Matthews, if you turn your camera on, thank you. All right, so this is a motion to remove an ankle monitor. It is Philip Matthews, 23 CP 219507. Mr. Fortis, it's aggravated assault. Mr. Phillips, turn your camera back on. Mr. Phillips, turn your camera back on.
Just a second on this.
It says the host has stopped.
There you go. Turn it back on.
Okay.
85. Judge, he's been out a year. He got out 6/19/2023. Nothing to add. He's only had one arrest before this, and it was back in 2010. Nothing further.
All right, go ahead, Mr. Fortis. It sounds like he's had it on over a year.
Yeah, Judge. The issue is twofold. Number one, regarding the ankle monitor, which has been over a year, Mr. White and I consented that should be removed. The issue where we're at an impasse is contact with his wife, Ms. Flores. Ms. Flores is on the call. I can stand in my place that I've spoken with her and that she wants to have contact. They haven't had any physical contact since June of last year. There has been some phone calls, only in that he has two minor children, 4 and 2. She moved to Texas. So in order for him to not be an estranged father, there has been phone conversations with the children. But at this point, over a year later, going on a year, 3 and 4 months, I mean, to keep them apart physically just doesn't make any sense. It's basically severing their relationship and making it more difficult. So we're just asking that there be no violent contact at this point. And I know that Mr. White has a different opinion on that, but I'll reserve based on what he may say.
But you said she lives in Texas now?
She had relocated to Texas. He is he's in the cabinetry business for carpentry. So he wants to relocate there with them at some point, but obviously given the bond requirement, he's unable to do so. But he's unable just to physically see her for that matter.
All right. What do you say, Mr. White?
Judge, although the state is not opposed to the ankle monitor since it has been on over a year and it hasn't been indicted yet, the state is opposed to allowing contact. This defendant, although there is a strict no contact, this defendant, by his own admission, by the representation of counsel, has violated that bond condition already, and has been in contact with the victim in this case. A year isn't all that long, especially given the situation that we're in. Still trying
Do you have children, sir?
Mr. Phillips, please mute yourself.
And Your Honor, this defendant, I'm just going to end with this, has shown through his behavior, not only in violating repeatedly the bond order, maintaining what can very well be characterized as almost constant contact with his victim, and has shown, and this forum, disdain for the court. The state is opposed to anything that would put this victim more at risk than she already is by someone who has so little regard for this court. Nothing further.
Judge,
So-
can I say, I'm sorry, go ahead.
Go ahead. No, go ahead.
What I was going to say is if, early on in these cases, what the DA's office always says is there needs to be a cooling off period. If, because nobody really knows what happened other than Mr. Phillips and Ms. Flores. However, now we're at the point where it's becoming a frozen situation. I mean, she wants contact. He wants contact. It's been over a year. They haven't had any physical contact. They have 2 minor children. He hasn't seen them because she's the only one that can transport them, or him transport himself to her. That has not happened. Yes, there has been phone calls only for the sake of the children, not being disrespectful to the court. But the bottom line is that the victim in the case who's on the call wants contact. He wants contact. And we're a year and 4 and 5 months into this without indictment. So, and there's no criminal history.
So, Mr. Portis, how old are the children?
I believe 4 and 2.
Okay.
It's a long time without a father.
Is there a third party that could do something as far as exchanging the children?
I mean, that can't happen now that, obviously they're in Texas. The only way that can happen is for either him to physically go there, and they're trying to get their relationship, their marriage back on track. I mean, this isn't a boyfriend-girlfriend situation. It's a marriage. I mean, she wants no violent contact, and I just think a year and 4 or 5 months is long enough. I mean,
When was his arrest date?
It was back on, I think the court had said that it was back on June the 19th, and that was the date of the incident back in 2023. So we're coming up on 16 months.
I'll include this on my email tonight to the state. Here's what I can allow. Here's what I'll do just right now. Only because I understand that she wants contact, but then I'm also kind of saddled with trying to protect people. So what I'll allow is, especially with the children, I get it. And so last time I brought this up, my God, we were on for like 45 minutes because these people couldn't get it. Zoom or FaceTime. And then both of y'all can record it if something comes up, and that would be evidence of good, you know, things that are happening or whatever. Do that. I'll include, I always include Mr. White. I'll include you too, Mr. Fortis, where I send an email to them. See, we can't get on the, get on something and get it indicted. So we can have, and I say Zoom or FaceTime, anywhere you can record it, because I don't know if the kids were there when this happened, and if they were, if it was a defects case or anything like that. But
They were not there. Well, I think one of the children's, based on the police report, were there when the alleged incident occurred.
How about we start with that? And
well, Judge, the only problem with that, and I'm not trying to get explicit on it or whatever. I mean, when I say they haven't had any contact, and when I'm talking about physical contact, like there's been no physical contact for 16 months for a husband and a wife. I mean, they need to have contact of some sort.
Well,
I mean,
you see, one I could not disagree. However, I go back to barely 30 days ago when a lady filed a TPO and she dismissed it and filed for divorce, and guy went over to her house and killed her. And I have to live with that.
What about if we structure it this way, that they can have physical contact, provided that, you know, maybe one of their parents are there as well. You know what I'm saying? Like they can see each other, and if they're in the house together, there has to be an adult third party. I mean, I know that that's hard to enforce, but it's almost there wouldn't be anything stopping her from driving from Texas to Georgia to see him. I mean, the state wouldn't know about that either if that's what she want to do. So they have been complying with that aspect of the court's order. So, I mean, I understand what the court's concern is, which is always the concern in these cases. But at this point, I just think that it's having a detrimental effect on their marriage and his ability to parent. You know, it's basically severing the relationship between not only his marriage, but also the relationship with his kids.
Let's see.
Can't go to ball games, can't go to school functions, all the things that all parents want to do.
Let's see. So I'm just reading the warrant, and it says, he called physical, substantial, visible bodily harm resulted in strangulation of another. Victim's face was struck with both open and closed hands, causing her face to become swollen, laceration on the side of her mouth, and hands and arms were pressed against her mouth and neck area, causing her to block out momentarily. See, bruising on the side. Elsa advised that she continued to get hit by Mr. Phillips while attempting to shield and remove her child from the immediate area. So,
what about some sort of amendment to the bond, Your Honor, regarding an evaluation, and then after that evaluation, or I don't know what it is, the 8-hour family violence, I think it is, or domestic violence course or something like that. Then after that, there can be contact.
You talking about like an FVIP class?
Yeah, but not the 26-week. I think there's one that's about 8 weeks or 8 hours or something like that.
We'll take the ankle monitor off right now, Mr. Allen. Find like a 6-8 week domestic violence class, and we'll reset it for that. Okay. Until then, though, you can have Zoom talks, both parties record it with your kids. I know it's a 2-year-old and a 4-year-old, and their attention span is probably that less than a gnat, but still, I want you to at least them to see you. I know it's an important time, and they've got what's the name of this place? Men Stopping Violence. I think they're Mr. Fortis.
That's what I was thinking about. Can he do that? Can we do the Men Stopping Violence?
Yeah, then send it to myself and Mr. White, and let us see what I think they do evaluations there, what they say.
What I would ask, and then I'm sorry, but can at least him and her have verbal contact?
Well, that's what I said. They can have Zoom or FaceTime, and I suggest both of them record it. I suggest that.
Understood.
So if somebody says, oh no, the judge allowed this and now he's screaming at me. Well, if she's recording it, she's got proof of it. If he's recording it, he's got proof that she's lying. I didn't scream at her because I record it all the time. Makes sense? Zoom, FaceTime, whichever they.
I'll draft a proposed order. I'll submit it and I'll send it to Mr. White.
But Mr. White, go to second chance bail bonds. You listen to me, Mr. Phillips. Where is it? It's over.
Yes, Your Honor.
Yeah,
Yes,
go
Your
back
Honor.
there and they can take it off. I thought I had that. Anyway, I think it's over there. Yeah, they can take it off. But reach out to the Men Stopping Violence, and of course, most of them know me over there, and just get something from them. Okay.
Yes, Your Honor.
All right, just hang in there a little bit longer.
Thank you, ma'am.
All right, thank you, Mr. Fortis.
Thank you, Judge. Hope your eye gets better.
Oh my gosh, getting old is not for the weak of heart.
Oh, please, I'm right there with you. Have a good one.
All right,
Bye,
thanks.
Mr. White.
Thank you, Judge. Thank you, Mr. Fortis.
Thank you, Mr. White. Looks like that's it.
Don't go anywhere. Don't go anywhere. I have work I have to do. Bear with me just one moment. All right. So I've already got the time codes here.
But again, explore decision, your own conclusions about this case individually.
Ladies
But
and
you
gentlemen,
should do so only after listening to and
I'm going to present to you the opening statements and the closing statements for the Jeffrey Bloom case trial, jury trial, happening in front of Judge Simpson today. This is hot stuff. This is not edited or anything like so. Just bear with me. I've written the time codes down here, so when we get to certain points, I'm going to just kind of have to fast forward, get to the next time code. Bear with me while I do that. But, ladies and gentlemen, that's you, Mr. Bloom, and Judge Simpson.
considering the opinions of the other jurors who may have different backgrounds and perspectives. Slandi, opening statement.
Thank you, Your Honor.
Good morning, members of the jury. We're here today, and I intend to produce evidence to show you that on May 30th of 2023, so last year, the defendant, Jeffrey Bloom, while being incarcerated at the Washtenaw County Jail, requested medical attention. He made it known that he felt he needed to have a medical professional come and evaluate him. Officer Navin, he asked Rocky Isley, a nurse, to come and look at this person. When Rocky came to evaluate the defendant, the evidence will show that Rocky deemed it necessary to check his vital signs. As a nurse, Rocky then touched the defendant's arm and took his blood pressure with a blood pressure cuff. I believe the evidence will then show that the defendant ripped his arm through that food slot while Rocky Isley was still holding on to it, slamming Rocky Isley into the metal cell door. I believe the evidence will then show that Rocky went to get medical attention later that day. The evidence I also believe will show that Rocky worked overnight. So he didn't get to go to the doctor until the 31st, but this did happen on May the 30th. At the end of the evidence, I will be asking you to return a verdict of guilty of assault and battery for the defendant. Thank you.
Thank you. Mr. Bernstein, would you like to give an opening statement now, reserve, or waive?
I'll go now, Your Honor. Thank you.
Very good. Proceed.
Being in jail the way Jeff was is stressful, it's difficult, it's rough. And where Jeff was staying specifically in the jail was more difficult than normal jail. He was isolated, he was by himself, couldn't interact with other people, he couldn't leave but for an hour a day. And when he left, it was in handcuffs, he couldn't shower. Often he wasn't able to shower 4 or 5 days at a time, and this took a toll on him physically, with his skin, with his hairs, getting skin lesions. It's not easy time. And this wears on you day after day, week after week. He was doing 7 months in that situation, and it gets to you, it gets to you physically, it gets to you mentally. Being told on this day that he couldn't come out and shower, that you don't get to shower today, continues to eat at Jeff. And just the inability to do basic human things is wearing at him. He's complaining of chest pains, and Rocky Isley shows up to evaluate him, and Jeff says, "I don't want you here." Tell him he doesn't want him there to evaluate him. Doesn't trust him, and Rocky has to convince him to let him take the vitals, okay? The situation, all this time, the agitation, the distress, the health problems, the mental anguish, it comes to a head in this encounter with Rocky. And following that encounter, decisions get made. Decisions to turn this into something that it's not, and those decisions have very real consequences for Jeff.
Can we approach?
May.
Oh crap. See, this is the problem right here. All right, so just pause it real quick. I'm looking. It's at this mark right about here.
Recalls case of People versus Jeffrey Bloom.
Oh, how good is that?
Good afternoon, Mayor Sam Bernstein with on behalf of Mr. Bloom.
And as I've apprised counsel, during the course of the trial, Mr. Bloom, I don't know, and I'm going to assume that at least for these purposes that you weren't doing it intentionally. There have been comments which I could hear all the way up here, and I'm sure the jury could hear it during the course of these proceedings. That then, when Ms. Lundy got up to give her closing argument, there were additional comments. I didn't do anything about that, but the moment the gyrations with your hands occurred behind her back, I stopped the proceeding. I'm not going to tolerate any of that. I will stop it again if that's what we have to do, but I'm going to admonish you and warn you at this time that the court is not going to allow that type of conduct to occur. With that admonition, Mr. Bernstein.
I was going to say there were some times where Jeff was speaking with me during the trial.
Oh, I understand that, but there were other points at which there were just extraneous comments. So I was letting those go, but I'm not going to have that and have counsel interrupted during the course of their closing arguments. With that admonition, are the parties ready for the jury?
Your Honor, I also understand there's been information given to the jury that.
Correct. Yes, for the purposes of the record, I did inform counsel. So at no, that the jury did not take that in any way to be applicable either to Mr. Bloom or to the people, because I had stopped Ms. Lundy in the middle of her closing argument. And I had indicated that they are not to take any delay or interruption by the court They are not to attribute it to either party. They are to attribute it to the court of its own doing, so that the jury understands that and does not hold that against the people or against the defendant.
Thank you, Your Honor. I am ready to proceed.
Is the defense ready?
I am ready, Your Honor.
All right, let's bring the jury. What is going on? All right. Go ahead. Thank you.
Still hot mic.
Oh.
Is he ready to, what's, pardon?
I don't think he wants. Sick, Your Honor.
No.
No. Did you want to go back there and try to talk with him? Because in the record should reflect, if it doesn't already, that after the court's admonishment to defendant and asking whether or not the people in defense were ready, that the defendant on his own accord decided that he would leave the courtroom. I've been informed by transport that it appears that he does not wish to come back out.
I really should try to speak with him, Your Honor. I mean,
yes, you should.
It's a significant right to be at your own, like in the Constitution or something.
One which one can, I believe, voluntarily forfeit.
That's fair too. Yeah.
So before we get to that stage, why don't I'll stand in recess and allow you to have an opportunity to chat. All right, thank you.
All right.
Okay, that happened, and that's not quite the end of it. So we'll hop over here to the next little piece, which is right about here.
Alan's trying to put the jury out. So.
Here we go.
Yeah, Alan's trying to put the jury out. So. All right. Okay, we're back on the record. Court does recall the case of the people of the state of Michigan versus Jeffrey Bloom. Counsel, state your appearances.
Pastor Lonnie for the people.
Sam Bernstein for Mr. Bloom, Your Honor.
All right, Mr. Bloom is not present. If I say anything incorrectly, please, counsel, correct me. Just prior to our last recess, when we were trying to continue with the trial, after the people had begun their closing argument, I stopped the proceedings, gave an admonishment, had the jury gave an admonishment to the defendant regarding comments that he was making, as well as gestures in terms of his hands because of the positioning of the podium behind the prosecutor's back. Gave him that admonishment, then told him that I would not tolerate any of that behavior. At that point, I did not hear anything, or at least nothing that was audible or understandable from the court in terms of the defendant saying anything. The defendant got up and he removed himself from the courtroom. Transport took him back. I took a recess in order to allow Mr. Bernstein to speak with his client. I was then informed during the course of that from transport that Mr. Bloom did not wish to return to the courtroom. And And so that's kind of where we were left. The question that arose as to whether or not this court, given the defendant's behavior, whether or not this court could continue with the trial, even though we just had closings and the verdict to go. Out of an abundance of caution, after speaking with counsel, and the court looking up for some guidance in this regard, the court did find me, I think it's Rule 43, I didn't bring my copy out of the federal rules, which specifically address the issue where a defendant removes himself from a trial in the middle of the proceedings or doesn't elect to participate. I did not see a rule specifically in the Michigan court rules governing that. As I did a brief research in trying to find cases, the case of the people of the state of Michigan versus Jerry Oliver Swan, that being 394 Mich 451, came to light. It was a 1975 case, so it's a little bit old, but it still looks to be good case law. I gave that to counsel, asked them to take a look, see if we could, between all of us, make a determination as to what would be the best way to proceed. And granted, I don't think anybody's had an opportunity to do any extensive research on it. However, I would indicate that if nothing else, the Swan case is illustrative of a point. And the synopsis basically indicates the Supreme Court held the defendant did not reappear in the courtroom after a mid-trial recess, had not reappeared 4 days later, and testimony was received regarding attempts to locate him. Trial court properly proceeded with the trial with receiving, part of the testimony in the jury's verdict in the defendant's absence. Taking that without anything else in front of me is sort of a guideline. The court believes that the defendant has conducted himself in a fashion where he has made himself absent mid-trial. It seems to me that what the Swan case seems to point to is that an opportunity be given where this defendant being in custody, we don't have to locate him, but at least an opportunity to be given to the defendant to come back and voluntarily participate in his trial. Having said all of that, after speaking with counsel, the court has made a determination to adjourn the remainder of the jury trial. We are adjourning it to September 30th, 2024 at 10 a.m. For closing arguments and final instructions to the jury. During that week period in time, in essence, the court is giving an opportunity for the defendant to reconsider his decision. Also to allow his counsel to have a conversation with the defendant as to what may be the implications of him having removed himself from the proceedings. But I think in fairness, and since they are monumental and rights that the defendant would be forsaking in terms of leaving his trial, the court thinks that it would be prudent for the court to do so. That was long, however. Either counsel have anything to add or to say contrary to what the court has indicated on the record?
All right, we're going to pause it there, and then I'm going to back it up. Back it up.
Parties prepared for closing argument?
Prepared.
You may proceed.
May I move the question?
Good.
Depends on where you want to put it, but yes, you may go.
Rotate it very slowly.
That's all right. That's
Thank you. Good afternoon. When we started this morning, I let everyone know what I expected the evidence would show. Started talking about that Rocky Isley was a nurse working in the jail, and on that date, the defendant was incarcerated in the jail. Talked about how we were going to hear from different witnesses about the defendant reporting to experience a medical emergency. We've heard from 3 different witnesses. First, from Officer Naveen, talked about how that was his assignment that day. The defendant had been upset that day. He talked about how he was upset even earlier in the day. He understood that the defendant was upset about something that had happened before Officer Naveen had even gotten there that day. We heard that he cannot ignore anyone's request for a medical emergency. Because Officer Naveen, Officer Tweedale, and Nurse Rocky Isley have a responsibility to make sure that the people in the jail are safe. That's their job. The corrections officers are there to make sure that the folks who are in the jail are okay. They don't make the decisions about who goes there. They don't make the decisions about who leaves. Their responsibility is safety. Officer Naveen is talking about how he checks every 15 minutes, make sure the people that are in his cell block are okay. He talks about how he makes sure Mr. Bloom is okay. Nurse Rocky tells you about how it's his responsibility when someone says they're experiencing a medical emergency. He doesn't care how old they are. He doesn't think something's more or less likely based on their age. He doesn't think something's more or less likely based on who they are. He is there to make sure they are okay. Officer Tweedale is the one who speaks to the defendant and says to him and gets him to calm down enough to be medically evaluated. Why? Because it's his job. That's his job. He's got to find a way to communicate with each person to help them. Nurse Rocky, I'm sure everyone has experienced a nurse who made you feel safe, who made you feel cared for and listened to. And Officer Tweedale, when this is going to go down and he knows that Mr. Bloom has been upset, and he knows that Mr. Bloom has been agitated. He told you how he levels his hand above the food slot door just in case. Why would you do that? Just in case. Safe. But the only person out of these 4 men who didn't care about the safety of another person was the defendant. You're going to get jury instructions in a few minutes that display for you and educate you that the law does not allow sympathy nor prejudice to influence when you are making this decision. You should not be prejudiced against the defendant because he was incarcerated, nor should you be sympathetic to him because he was incarcerated. The law requires an examination of the facts. And the facts are simple. The facts are the defendant was in the jail in Washtenaw County. The facts are that the defendant said he was having a medical emergency. The facts are that earlier in that day, he'd been very upset. He was not allowed to get out of his cell. The facts are that he was a level 1 security. The facts are that he had to be medically evaluated through his food slot. And the facts are that when he was being medically evaluated, He yanked his arm back in that food slot, and that slammed Rocky Isley into his wall, or into his door, rather. Now, I can't tell you what defense argument there might be, but I will tell you that you've seen a video, not my favorite angle. You've seen medical records, and you've got a copy of Rocky Isley's own statement that he made on May 31, the day after this happened in the night, about what happened. Everyone has a right to be safe at work. Everyone has a right to be safe in their homes. All of the witnesses that you've heard from today helped to keep the defendant safe at his home. His home he didn't choose. He didn't choose to be in the jail, but that's where he was. Each of those men told you how they made a choice to keep him safe, despite his behavior, despite
Ms.
his.
Lundy, stop for a moment.
I'm sorry, Frank.
I apologize. Take the jury, please.
I'm so sorry, Your Honor.
No, it's not you. It's not you. Take the jury, please. Ms. Lundy, everybody may be seated. And I apologize for interrupting you in the middle of closing.
I'm
The
terribly.
behavior from Mr. Bloom, I am not going to have in terms of his gestures, his noise and everything, particularly behind Ms. Lundy's back. Not going to have it. Mr. Burnton, I'm going to give you a chance to talk to your client about it and tell him that he is to sit there quietly or not at all before I continue. Take him back. Court is standing in recess.
All right.
So that's the part we missed. That's the part we missed. So on the 30th, we will see what remains of closing arguments and sentencing, or whatever. I mean, the jury has to come back, right? So, yeah, I mean,
What recalls the case of People versus Jeffrey.
we saw the
Bloom.
admonishment there.
Good afternoon, Mayor Sam Bernstein with on behalf of Mr. Bloom.
These were the
And
admonishments
as
we
I've
watched
apprised
first.
counsel, during the course of the trial, Mr. Bloom, I don't know, and I'm going to assume that at least for these purposes that you weren't doing it intentionally. There have been comments which I could hear all the way up here, and I'm sure the jury could hear it during the course of these proceedings. That then, when Ms. Lundy got up to give her closing argument, there were additional comments. I didn't do anything about that, but the moment the gyrations with your hands occurred behind her back, I stopped the proceeding. I'm not going to tolerate any of that. I will stop it again if that's what we have to do, but I'm going to admonish you and warn you at this time that the court is not going to allow that type of conduct to occur. With that admonition, Mr. Bernstein.
I was going to say there were some times where Jeff was speaking with me during the trial.
Oh, I understand that, but there were other points at which there were just extraneous comments. So I was letting those go, but I'm not going to have that and have counsel interrupted during the course of their closing arguments. With that admonition, are the parties ready for the jury?
Your Honor, I also understand there's been information given to the jury that.
Correct. Yes, for the purposes of the record, I did inform counsel. So at no, that the jury did not take.
Well, guys, I went a lot longer than I expected. Been a 2-hour extravaganza over here. We did a bunch of Manic. We did some Simpson. It was all crazy. I will be cutting that Simpson up into a video. Old Squishy Gardener has a video out right now if you want to watch. Pretty much all of the good stuff. You can pretty much go to Old Squishy Gardener's been covering Bloom and Simpson's court and Slay's court since the beginning. So if you want to see the whole history, how it began, go to Old Squishy Gardener. The camera's messed up because we were playing with the cat earlier. So guys, thank you for coming by tonight. Been a blast. Chat's been fun as always. Cases have been interesting as always. We do this every Monday night. We don't always have little special presentations like that every Monday night, but we did tonight. I have been your Lone Wolf Usul, and I have been your curator and host. Come by on Saturday. I do a case review for the week. Usually includes some Fleischer at the end. About the Friday Fleischer ending. It's always good when Fleischer's around. Come by. Check it out. That happens at noon Eastern Time, Saturdays. This happens every Monday at 7 p.m. Same Wolf time, same Wolf channel. See you next time. Thanks guys for coming out. See you.